So very good evening, all the participants. Today we shall be covering the allied laws. So lot of laws are there in our syllabus. I hope my screen is screen just a minute. Yes. Now I think my screen is visible. Yes, is it visible?
Yes, sir.
Okay. So general laws. What it says? Limitation Act. And there are various sections or articles which have to be specifically remembered. Prevention of Corruption Act, Prevention of Money Laundering Act, RDP, Arbitration and Conciliation, SURFACE Act, MSMED, RERA, Mediation Act, Digital Personal Data Protection Act, EPF, and Miscellaneous Provisions Act. And besides that, SEBI regulations are also there. So SEBI regulations I have clubbed with business laws, like with Companies Act, because it aligns more with those acts. Okay. So we'll try to cover, let us see how much we can cover today. Right. So the Limitation Act. What is the object and what is the key principle of this Limitation Act? We'll try to summarily cover all these provisions. Right. For detailed lecture on each of these acts, there are already video lectures available. So I'll post that playlist in the group. So what is the object? So it protects defendants from stale claims, because law also feels that claims should be settled, issues should be settled as soon as possible. And it ensures judicial certainty also. But Limitation Act, it extinguishes the remedy and not the right. Despite the Limitation Act, if you want to pay, you can pay. And a time-barred debt still exists as a natural obligation, but of course it cannot be enforced in a court of law, because the lawmakers feel that if you are lax in pursuing the remedy, then you should not be allowed beyond a particular time. That is the basic of this Limitation Act. Now,
आपका जनरल लॉ का ही पेज खुला हुआ है, सेकंड स्क्रीन नहीं आई।
कौन सी?
सर आपने जो पीडीएफ फाइल खोली है वो जनरल लॉ ही दिखा रहा है, सेकंड पेज नहीं दिखा रहा है।
अच्छा अच्छा अच्छा, एक मिनट मैं दोबारा से, वो से लगता है कि हाँ हाँ हाँ, नाउ आई थिंक इट इज विजिबल।
यस सर, अब आई है
है ना?
विजिबल।
हाँ ठीक है, वो कई बार हाथ लग गया होगा बात करते
नहीं,
करते।
इट्स ओके सर, इट्स ओके।
So Article 36, there are various articles in this, and Article 36 deals with the recovery of money lent under a written instrument, basically loans. So the period of limitation in this case is 3 years, and the starting point is the date of loan or demand per instrument. Article 37 talks of money payable under judgment or a decree order of the court, and the period for enforcement is 12 years, and this period of limitation starts from the date of judgment. Article 64 talks of this recovery of possession of immovable property, and in case of recovery of possession of immovable property, the limitation period is 12 years, and it is the starting point is the date of the dispossession. Article 113 covers any suit where no period has been prescribed, residuary suit. So the period here is 3 years, and the starting point is when the right to sue first accrues. Article 137 talks of any other application, residuary, including section 7 and section 9, and the period is 3 years, and the starting point is when the right to apply first accrues. So normally the period is 3 years, but in the Limitation Act, if you go in detail, there are various schedules which prescribe the period. Like in case of torts, the period is 1 year. Normal period is 3 years. In case of immovable property, the general notion is that the period is 12 years. Section 5. What are the important sections? So Section 5 talks of condonation of delay. And it says that this section applies to appeals and applications only and not suits. Right? And if you are applying for condonation of delay, in case you are not able to file the application, if you are not able to file the appeal in time, then you can apply for condonation of delay by citing sufficient cause. The sufficient cause could be illness, it could be by fraud, it could be mistake in legal advice. Suppose your advocate advises you in a wrong way and you move to the court which is not of competent jurisdiction. So then delay could be condoned. But here the court has discretion. It may or may not grant condonation of delay, but normally it grants condonation of delay. A very important judgment of Supreme Court is Master Katiji here, which says that by delaying a appeal or application, the appellant is not gaining anything. So it says the court should not be hyper technical while granting condonation of delay. I'll cite that judgment also in the, I'll post that judgment in the group complete citation. It's a very good judgment, just 3-4 pages judgment, but it's very good on law of limitation. Section 18. Section 18 talks of acknowledgement, and it says the period of limitation starts again from the date of acknowledgement, but it must be in writing. It must be signed by the parties liable. It should be made before expiry, and it should be acknowledgement of that specific liability. So the effect of acknowledgement is that a fresh 3-year period starts from the date of acknowledgement. Section 19 talks of part payment, and it says whenever any part payment is made, then fresh limitation starts from the date of that payment. And no return form is needed for part payment. Even the NEFT or RTGS records should be sufficient. And if payment is on account of principal or interest before expiry by the person liable, so then every part payment leads to fresh limitation period from the date of payment. Section 22 talks of continuing breach or tort. So it says where breach of contract is continuous, for example, ongoing non-repair, then fresh limitation accrues at every moment of continuance, and no limitation bar is there for recurring obligation. Right. The important cases which I think are covered in our syllabus also, BK Educational Services versus Parag Gupta. So it says Limitation Act applies to IBC, Section 7 or Section 9, 3 years from the date of default. But it is not from the date of demand, it is from the date of default. So IRP must check the limitation for every claim, and stale claims are liable to be rejected unless the party has got condonation of delay. Asset Reconstruction Company versus Bishal Jaiswal. So it says if there is an entry in the balance sheet which is acknowledging a liability, it is deemed to be an acknowledgement under Section 18 of the Limitation Act. And the directors who sign the balance sheet, they bind the company, and fresh 3-year period shall start from the date of signing of the balance sheet, because signing of the balance sheet by directors amounts to acknowledgement of debt under Section 18 of Limitation Act. Prevention of Corruption Act, 1988. Section 7 talks of public service. In Prevention of Corruption Act, normally they will ask you the penalty provisions. So Section 7 talks of public servant who is accepting or agreeing to accept gratification or bribe for doing or not doing any official act. Minimum period is 3 years, maximum period is 7 years, plus fine can also accompany this imprisonment. Section 7A deals with giving or promising undue advantage to public servant. The minimum period is 3 years, maximum is 7 years plus fine. Section 11, public servant obtaining valuable thing without adequate consideration from person with interest in proceedings. So the punishment here is 6 months to 5 years plus fine. Section 12 covers the abatement of offences under Section 7 and Section 11. So anyone who abets an offence which is covered under Section 7 or Section 11, so the punishment here is the same as of the principal offender. Section 13 talks of criminal misconduct by public servant. The punishment is 3 years to 7 years plus fine. Normally, they will ask you question on section 14, habitual commission of offences. So, if somebody is a habitual offender, then the punishment is slightly increased 5 years to 10 years plus fine. So, normally they will ask question on this. Section 15 talks of attempt to commit offence under section 13(1)(a), and the punishment is up to 3 years. And section 16 talks of property in the name of personal guarantor or relative. It is presumed to be bribe if it is disproportionate to his known sources of income, and the punishment is same as under section 13, right? Because sometimes what you do not purchase the property in your own name. So you may purchase property in the name of someone who has stood as a guarantor or who is your relative. And this is also considered to be bribe. It is presumed to be bribe if it is disproportionate to the known sources of income of such guarantor or relative. And it is deemed to be criminal misconduct also. As we know, section 29A also covers this. So section 29AD of IBC says that if the offence is covered under 12th schedule, which includes this Prevention of Corruption Act also, then persons convicted for offence with imprisonment of 2 years or more, so they are ineligible to submit a resolution plan. This section 29A is to be construed strictly, and no time-based exception for Prevention of Corruption Act conviction. Convicted means ineligible. So no cure by payment of fine. Next law to be covered here is Prevention of Money Laundering Act 2002. So section 3 says, whosoever is directly or indirectly attempts to indulge or assists in any process or activity connected with proceeds of crime. Now, what is important here is the proceeds of crime. So, this Money Laundering Act is attracted, Prevention of Money Laundering Act is attracted only when the activity is connected with proceeds of crime. If you are indulging, if you are assisting in any process or activity connected with proceeds of crime. Now, what is proceeds of crime? Any property which is derived or obtained directly or indirectly as a result of criminal activity relating to a scheduled offence, right? Attachment, prohibition of transfer, conversion, disposition or movement of property by an order. And who can order attachment? Section 5 talks of the provisional attachment. So here a director, deputy director of under Prevention of Money Laundering Act, he attaches the property which is believed to be proceeds of crime, and the period of provisional attachment is 180 days. Section 6 talks of the adjudicating authority. This is the independent adjudicating authority under PMLA, which confirms or releases the provisional attachment. Under section 7, you can go in for appeal, and appeals against the adjudicating authority PMLA order lie to the appellate tribunal for PMLA. And section 8 talks of confiscation, and after the order of the adjudicating authority confirming attachment, property stands forfeited to the central government. Scheduled offences are covered under section 2(1)(y), which is these are the offences listed in the schedule to PMLA, and it includes IPC, offences covered under IPC, NDPS, FEMA, Companies Act or IBC. Normal punishment in case of PMLA is 3 years to 7 years, but in case of offences which include NDPS matters, the punishment could be from 3 years to 10 years. Recovery of Debts and Bankruptcy Act. The jurisdiction here is only banks and financial institutions are allowed to avail this process, and where the debt amount is 20 lakhs or more. So in case of normal people who are not banks or financial institutions, so the courts of civil courts or commercial courts is open for them. and counterpart proceedings from borrowers are also entertained. Presiding officer here is the recovery officer, one, plus presiding officer of judicial level and quasi-judicial tribunal is there. Recovery certificate is issued on the order in favor of the bank, and recovery officer issues the recovery certificate, which can lead to attachment and auction. The limitation period is 3 years from the date of cause of action, and the Limitation Act applies to RDB Act also. So if there is a default of 20 lakhs or more, banks and financial institutions can file a suit here within 3 years from the date of cause of action. And borrowers can also start counterpart proceedings. An appeal from the DRT lies to DRAT, and the appeal has to be filed to DRAT within 30 days of the order of DRT. But a pre-deposit of 75% of the debt amount is required. But if the aggrieved party cites grounds of hardship, then DRAT has discretion to reduce this amount on recording, after recording reasons therefore. There is a bar on proceedings to be initiated in civil courts. So jurisdiction of civil courts is barred in matters where DRT has authority under this, right? Now let us see the judicial or jurisdictional conflict between RDDB versus IBC. Section 238 of IBC says that IBC prevails over all other laws including RDDB Act. So NCLT has the exclusive jurisdiction to settle matters relating to insolvency. Section 14 talks of moratorium, which says that once the CIRP is initiated, once CIRP commences, so all DRT proceedings against the CD are stayed. So DRT cannot enforce recovery certificate against the assets of the CD. Personal guarantor. So DRT proceedings against personal guarantor may continue, but moratorium does not extend to personal guarantor, as cited in SBI versus Ramakrishna. Post CIRP, if resolution plan stands approved, then the debt stands extinguished and DRT proceedings abate. But if the matter goes into liquidation, then DRT stays and claim can be filed with the liquidator. In Bank of Baroda versus MBL Infrastructures Limited, it was held that CIRP moratorium, it stays all DRT proceedings against the corporate debtor. Next law, which we can see summarily, is the Arbitration and Conciliation Act. So it covers domestic as well as international commercial arbitration, which are covered in Part 1. Part 2 covers enforcement of foreign awards, which have to be dealt with as per New York Convention and Geneva Convention. And Part 3 deals with the conciliation, and conciliator facilitates the settlement, and settlement agreement is enforceable as arbitral award. So Section 7 talks of the arbitration agreement. So arbitration agreement is the written agreement, which is a signed document. It could be in the form of a letter, telex message, claim or defense, it could be by way of a clause in the contract, or it could be a separate agreement regarding the arbitration. Section 16 talks of competence. So tribunal rules on its own jurisdiction. Challenge must be raised before tribunal first and before statement of defense, only via Section 34 application later, and not by approaching court during arbitration. So it says the tribunal rules on its own jurisdiction, and challenge must be raised before the tribunal first. Section 17 talks of the interim measures which the tribunal may take, and post 2015, so tribunal's Section 17 order is enforceable as a decree of civil court directly, and no court conversion is needed, which was needed prior to 2015. Section 34 deals with challenge to award. It says that any arbitration award could be challenged but on limited grounds only. The grounds could be incapacity of the parties. The ground could be invalid agreement. No notice was issued. It is beyond the scope of arbitration. Improper composition of the tribunal. Non-arbitrable subject. It is against public policy. It involves fraud, corruption, or it is against the fundamental policy of Indian law. So time limit is here is 3 months from the date of receipt of the award plus maximum 30 days. No further extension shall be allowed. So challenge to award could be made within 3 months from the receipt of the award, plus it could be extended by 30 days. Section 40 deals with death of the party during arbitration. So arbitration agreement is not discharged by death and it continues to be binding on legal representatives. Section 41 talks of insolvency, and if the party is declared insolvent, then arbitration proceedings continue, and regarding property of insolvent, it may continue subject to insolvency court control. Section 43 deals with limitation, and it says Limitation Act applies to arbitration, and arbitration commences on the date of request received by the respondent. Section 45 deals with reference to arbitration. So court refers parties to arbitration unless agreement is null or void or inoperative or incapable of being performed. Section 238 of IBC says that IBC overrides arbitration clause and insolvency is not arbitrable. Like we were discussing a few days back also, that if a Section 7 application is filed, then tribunal cannot say that you go to arbitration. So NCLT has exclusive jurisdiction, and moratorium stays pending arbitration and enforcement of awards against CD. Okay. In Gujarat Urja Vikas Nigam versus Amit Gupta, it was held that NCLT can terminate contract even with arbitration clause. Now let us see regarding the SURFACE Act. So first of all, SURFACE Act covers only secured loans. So unsecured loans are not covered here. First of all, if the bankers want to take action under SURFACE Act, they have to classify their account as NPA. So borrower account is classified as substandard, doubtful or loss as per the RBI norms. Only then you can issue notice for invoking provisions of SURFACE Act. So once the account is classified as NPA, then step 2 is you issue a 13(2) notice, section 13(2) of the SURFACE Act notice. So it is a demand notice which is issued and which says that borrower has 60 days to repay the loan, failing which coercive action can be taken against the borrowers by repossession of the assets which already stand mortgaged to the bankers. So step 3 is section 13(3)(a), which gives the right of representation to the borrower. So borrower may represent within 60 days and bank must consider and give reasons for rejection of the representation by the borrower. Step 4 is action under section 13 subsection 4. So once a notice is issued under section 13(2) and no reply is received within 60 days, then the secured creditor can take possession, he can sell, lease or appoint manager to the assets. Step 5 is seeking assistance from the district magistrate. So if there is a resistance from the borrower, so the secured creditor can apply to the district magistrate or chief metropolitan magistrate for physical possession, and normally they have to revert within a period of 30 days, right? It could be extended by 60 days. Section 17 talks of the right of appeal by the borrower. So aggrieved person may apply to the DRT within 45 days of any action taken under section 13 subsection 4. And if it is proved that there was no default or the measures were excessive, then assets could be restored to the borrower. Section 26C says that SURFACE registration is mandatory if you want to take action under SURFACE. So the registration of security interest is mandatory. And if you fail to get the security interest registered, then security is unenforceable against the liquidator or IRP or receiver in insolvency. Section 34 talks of the jurisdiction bar. So no civil court shall have jurisdiction over matters where DRT or DRAT is empowered to determine such matters. Right. So no stay or injunction is normally granted by the courts. So section 14 talks of the district magistrate, which shall assist the bankers in taking possession. And IBC section 14, it talks of moratorium. So it prohibits all possession attempts. And in case of conflict, then IBC prevails. So during CIRP, no SURFACE action can take place. But as soon as CIRP is over and the company goes into liquidation, then the secured creditor, as per section 33 subsection 5, read with section 52. So now secured creditor has got two options during liquidation. He can either enforce the security interest outside the liquidation, right? So SURFACE is now available because moratorium has ended, or it may opt to relinquish the security and participate in waterfall, and he has to exercise this choice within a period of 30 days through the claim form in column number 8A, right? This we have already read. NPA definition. It is an asset or account of the borrower which is classified by bank as substandard, doubtful or loss asset as per IBI prudential norms. Regarding SURFACE, IRP must check the SURFACE database, and unregistered security is unsecured creditor in CIRP. Because while taking action under section 52 also, the secured creditor has to prove the security interest through records of SURFACE, MCA or NESL. MSMED Act. The definition, which has undergone changes from time to time. So micro enterprise, small enterprises and medium enterprises are covered. Investment in plant and machinery or equipment where it does not exceed 1 crore in case of micro, and turnover does not exceed 5 crores. In case of small enterprises, investment in plant and machinery or equipment does not exceed 10 crores and annual turnover does not exceed 50 crores. And in case of medium enterprises, investment does not exceed 50 crores and annual turnover does not exceed 250 crores. And both criteria must be satisfied. The higher category prevails, right? Investment is less than 1 crore, but turnover is more than 5 crore, then it is not considered as a micro. It will be covered under small, right? So as per our syllabus, these figures are relevant. Although the definition of MSME has undergone changes after this period also, but that was in 2025, in budget 2025. So that is not applicable for our syllabus. So we have to remember these figures. Section 15 says that if you are liable to pay to a unit which is covered under MSME, then you have to pay within the agreed period or within a period of 45 days from the date of the acceptance if there is no agreement. But no agreement can extend it beyond the period of 45 days. So it gives relief to MSME units to get the payment within a definite time frame so that there are no working capital difficulties. Section 16 talks of interest on delayed payment. So it is, if there is a delay beyond the period of 45 days, then interest at the rate of 3 times the bank rate, which is compounded monthly, is payable, and this interest starts from day 46. Section 17 talks of the right to file claim before MSE Facilitation Council, Micro and Small Enterprises Facilitation Council, because these facilities of interest payment, they are available only to micro and small enterprises and not medium enterprises. Section 18 says that if the efforts before Micro and Small Enterprises Facilitation Council fails, then it may be referred to arbitration. And this award of Micro and Small Enterprises Facilitation Council, it is enforceable as a decree of the court, and buyer must deposit 75% to challenge this. Section 22 says that the buyer's turnover should not exceed, if it exceeds 40 crores, then it must disclose outstanding MSMEs amounts in annual accounts while furnishing its tax audit report. And that outstanding amount is disallowed. Section 23 talks of interest on delayed MSME payment. It is not deductible under Income Tax Act. The relevant section in IBC for MSME is Section 240 capital A, which says that the ineligibilities which are covered under clause C and H of Section 29A dealing with NPA accounts and invocation of guarantees shall not apply to a resolution applicant in respect of an MSME corporate debtor. So, if CIRP of a MSME corporate debtor is taking place and there is a resolution applicant, then while considering the applicability, we don't have to see the clauses C and H of Section 29A. So, MSME promoter can submit resolution plan for same MSME CD even if personal guarantee is invoked, right? Because MSME business are owner managed and promoter has unique expertise, and it prevents automatic liquidation. Section 43BH of Income Tax Act says that MSME payment is deductible only on actual payment and not on accrual basis. So, if paid within MSMED Act limit, and delayed payment means deduction will be disallowed for that financial year. Suppose you have procured goods from micro or small enterprises, right? And you do not pay to them, then the purchase amount will be disallowed, and it will be allowed in the year in which you make the payment. This is the meaning. Real Estate Regulation and Development Act, RERA. So first of all, we have to see the definition of the real estate project. Real estate project here means development of building, apartment or plot for sale with area which is more than 500 square meter or more than 8 apartments. In certain states, it is 6 apartments also. So it differs from state to state also. Promoter here is person who constructs or develops a real estate project for sale and includes builder or developer. Allottee here means the person to whom apartment or plot is allotted, and he is considered to be a home buyer. And carpet area here means net usable floor area excluding outer wall thickness, service shafts and exclusive balcony, but internal walls are covered. And this allottee, it could be a commercial project also. It need not be a residential project only. So allottee here means anybody who is allotted in an apartment or plot in a building under a RERA approved project. Section 3 mandates registration. So registration is mandatory before you release any advertisement or if you start any booking or selling. So threshold is more than 500 square meter or more than 8 apartments, and it is disjunctive. So or either triggers registration, right? So whether it is 500 square meters or more than 8 apartments, then the registration threshold is triggered. Section 5 talks of grant, and it allows the RERA also a limited time. So registration has to be granted or rejected within a definite time period not exceeding 30 days. And if no order is received, either granting registration or rejection, then it is deemed to be registered. Section 11 subsection 3 talks of escrow account, which prohibits these builders from using this money for administrative purposes. So 75% of the advance which is received from the allottees it has to be deposited in a designated bank account only, and it is to be used only for construction plus land cost of that specific project, right? And in case you use it for some other project, then also it is considered to be a violation. Section 11 subsection 4 talks of advances, and not more than 10% of the apartment cost is accepted as advance before executing any written agreement for sale. So if you want to have more than 10%, then you have to execute a written agreement for sale. Section 18(1) talks of the remedy which the home buyer may avail in case of delay. So allottee may here apply for refund along with interest, or he may like to continue with the allotment, plus he may demand interest for delay in receipt of possession. Section 18(2), very important section, and normally they are asking question on this these days regarding defect. So what is the time period when any structural defect could be pointed out? So this time period of pointing out structural defect is 5 years structural defect liability from the date of possession, and such defects have to be rectified within a period of 30 days. Section 42, another important section where they normally ask the questions. So section 42 deals with the appeal, and it says appeal from the orders issued by RERA lie to the Real Estate Appellate Tribunal (REAT) within a period of 60 days, and further on question of law on, right? These are the cases which you can go through. Next is Mediation Act and this Digital Protection and Data Protection Act. Mediation Act. So mediation, section 5 talks of the pre-litigation mediation. So it says party may attempt mediation before filing any suit or proceeding. Section 8 talks of court-referred mediation, wherein the court or tribunal may refer disputes to mediation at any stage. The duration as per section 21 is 60 days, and it is extendable by 60 more days by consent, maximum 120 days total for the mediation to take place. Mediated settlement agreement, which is covered under sections 27 and 28, and it says this mediated settlement agreement is binding and it is enforceable as judgment of the court, and it can be challenged only on fraud, corruption or impersonation grounds within a period of 90 days. Regarding confidentiality, section 22 says that all proceedings under Mediation Act will be confidential in nature and mediator cannot testify in court. Regarding this DPDPA Act, there are certain definitions which are being asked in the exam. Data principal, data fiduciary. These are the two most important definitions on which they are asking questions. So data principal is the individual to whom the personal data relates, and he has rights of access, correction or erasure of that data. Data fiduciary is the person who determines purpose and means of processing personal data. Equivalent to GDPR, data controller. So it bears primary responsibility. Data processor is the person who processes data on behalf of data fiduciary, for example, cloud providers. Consent under section 6 talks of explicit, specific, informed, unconditional and ambiguous consent is required before processing of data. Data Protection Board, the adjudicatory body which inquires into the breaches, issues or directions or imposes penalty. And maximum penalty here is up to 250 crores for a breach of significant data fiduciary. Employees Provident Fund and Miscellaneous Provisions Act. EPF scheme. Employer's contribution here is 3.67% of basic wages, and 8.33 it goes into employees pension scheme. In case of employee contribution, 12% of basic wages go to the employees provident fund. So this PF accumulation is withdrawable on exit or retirement. And this amount which is deposited in employees pension fund scheme, it is payable as monthly pension on retirement, death or disability. Section 2 covers the certain definitions. Section 6 talks of contributions. Section 8 mode of recovery. Section 11 priority of payment. Section 14 punishments. So employer fails to pay contributions, then there could be imprisonment up to 3 years plus fine. And section 17 talks of exemption. So it says central government may exempt establishments from EPF Act if private trust PF is better than the scheme. Just a minute. So in case of Limitation Act, normally Article 136, prime importance, 3 years. So core principle is limitation extinguishes the remedy, not the right. And section 18 says that balance sheet, any figure appearing in the balance sheet amounts to acknowledgement of debt. Prevention of Corruption Act, normally the punishment is 3 to 7 years, but in case of habitual offenders, the punishment is 5 years to 10 years. So it has a wide definition of public servant. And this prevention of corruption, any conviction under Prevention of Corruption Act, it leads to disqualification under IBC also. In PMLA, the imprisonment is rigorous, right? It is not simple imprisonment, it is rigorous imprisonment from 3 to 7 years. And in case of NTPS offences, it is 3 years to 10 years. So, but it should be involving proceeds of crime. And these proceeds of crime are attachable under section 32A of IBC. Because post RP approval, the immunity which is given under section 32A, it is available only for genuine resolution applicants. In case of RDDB Act, the threshold is 20 lakhs or more. So DRT for debt recovery by banks, and section 238 of IBC overrides this, and CIRP moratorium, it stays the DRT proceedings including any recovery action. Yes. Now let us do some question answer session also. In case of Limitation Act, a bank extended a term loan in January 2019. Last installment was due on 31st of March 2020. It was not paid. Axis balance sheet for financial year 2021 signed by the director on 30th September 2021. It showed the outstanding loan. So bank files the section 7 IBC application on 15th October 2023. So is it time barred? The answer will be no, because you have to reckon the 3-year period from 30th September 2021, which is the date of signing of the balance sheet by directors, right? So because as per section 18, the balance sheet which is signed by the director, it amounts to acknowledgement of debt, and acknowledgement is binding on the company. And fresh 3-year period starts from 30th of September 2021. X files a suit for recovery of money 4 years after the 3-year limitation period. X applies under section 5 for condonation, citing serious illness. So what the court should do? Because it applies only to appeals and applications and not to suits. So the court will reject this application for condonation of delay under section 5. So section 5 says any appeal or any application may be admitted after prescribed period. Suit is deliberately absent. So in case of suit, no condonation is possible. Section 3 says every suit filed after the period shall stand dismissed. P verbally acknowledges rupees 10 lakhs debt in 2021 within limitation. In 2021, P makes NEFT of rupees 50,000 with memo towards old dues. Q files suit in 2025. Is it time barred? It is not time barred because part payment, although it may not be backed by any agreement. So simply an NEFT transfer or RTGS transfer will amount to acknowledgement of debt, right? As per section 19, and fresh period shall start from 2022, the date of payment. So section 19 says part payment before expiry by person liable leads to fresh 3-year period. Because an NEFT payment was made in 2022, so it amounts to valid part payment, right? In case of continuing breach of trust, lease from 2015 requires B to carry out repairs yearly. So there is a lease agreement between two persons which says that B shall carry out the repairs on a yearly basis. So B fails from 2017 and A files suit in June 2024. B raises the period of limitation here. So A's suit is not barred because non-repair is a continuing breach, because he was expected to carry out the repairs on a yearly basis. So non-repair is a continuing breach and fresh limitation accrues daily. Section 22. Prevention of Corruption Act. Mr. A was convicted under section 138 of the Negotiable Instruments Act and he was sentenced to 1 year and 6 months of imprisonment. And he completed the sentence and paid fine. In 2024, he submits a resolution plan. Is he eligible? The answer is yes, because the schedules which are covered under IBC, the punishment is 7 years. So this 2 years applies to the acts which are given in 12th schedule only and where Negotiable Instruments Act is not listed. And maximum prescribed punishment here is 7 years for other laws. So he will be eligible. Prevention of Corruption Act 1988. RP as public servant. Undisclosed post-plan advisory fees. So RP, Mr. R's COC approval fees was 8 lakhs per month, and after NCLT plan approval, RA privately pays him 25 lakhs as success advisory fees, which was undisclosed to the IBBI or COC. Mr. R's criminal exposure under Prevention of Corruption Act is under section 7 of the Prevention of Corruption Act, because RP is public servant under section 2 subsection C. And any undisclosed payment means undue advantage regardless of solicitation. So RP is a public servant under section 2 subsection C under of this Prevention of Corruption Act, because he is performing a public duty under IBC, which is NCLT supervised. PMLA. A resolution plan for Emerald Steel was approved by NCLT. RA is independent. No connection to promoters. Before RP, before resolution plan, ED had provisionally attached the factory under PMLA. Now post the resolution plan approval, ED seeks to continue the attachment. So whether ED can continue the attachment, because here the resolution applicant is independent. He has got no connection with the promoters, and any resolution applicant which has got nothing to do with the old promoters wrongdoings, so then he is granted immunity under section 32A. So ED cannot continue this attachment. Section 32A of IBC, it extinguishes all criminal liability and attachments if the resolution applicant is a genuine third party which has got nothing to do with the previous promoters. PMLA 2002, provisional attachment during CIRP. Company Y in CIRP, RP has custody of all assets. And ED issues provisional attachment order on section 5 of the PMLA on 15th July 2024, attaching Y's warehouse. The correct position is attachment is invalid because section 14 of IBC, by virtue of moratorium, it prohibits action to take possession of the assets of the CD during moratorium period. DRAT. Deposit description. Because if anybody is aggrieved against the orders of the DRT and he appeals to DRAT, then there is a condition of deposit of 75%, but it could be reduced also as per the discretion of DRT. So bank gets DRT order against company Z for 5 crores. Z appeals to DRT seeking exemption from 75% deposit on grounds of financial hardship. So DRT has the power, it can reduce or waive the 75% pre-deposit on sufficient cause being shown, because it has discretion, but it has to record reasons in writing. Arbitration Act, section 16, competence. So FC here files section 7 IBC application against company P. P argues the loan agreement has an arbitration clause. So he says that we should go in for arbitration first because the loan agreement has got arbitration clause. So FC must go to arbitration first. So NCLT, what NCLT should do in case an application is filed on default and application is complete, then NCLT should admit the section 7 application, because section 238 of the IBC, it overrides any other act including arbitration act. So it overrides the arbitration clause, and insolvency is not arbitrable, and NCLT has exclusive jurisdiction to decide matters regarding insolvency. Time limit for challenge under arbitration. Award here was passed on 1st of August 2024, but losing party received the signed copy on 15th August, and section 34 application was filed on 20th November. So here we have to see whether it was filed after 3 months or not. So the application here is within the prescribed period of 3 months from 15th August 2024. So anytime up to 14th November he can file. Okay? But proviso allows 30 more days if it is filed on 20th of November. So this is within the condoned period of condonation is granted. So court may condone up to 30 days more on sufficient cause being shown. So 30 days from the date of receiving the signed copy plus another 30 days as per the discretion of the court on sufficient cause being shown. Arbitration Act 1996, enforceability of tribunal's interim orders. So while arbitration is in progress, tribunal passes section 17 order restraining Y from alienating the assets. But Y ignores it and X seeks to enforce So what is the correct position? So X can enforce section 17 order as if it were a decree of civil court which is directly executable. So post 2015 amendment, tribunal's order under section 17 shall be deemed to be an order of civil court and it shall be enforceable as such. Okay? So no conversion to section 9 court order is needed and it is directly executable. Surfacing 60 days notice. So bank issues 13(2) demand notice on 1st June and it asks the borrower to pay within 60 days. On 20th June 2024, borrower sends representation disputing the NPA classification and bank does not reply. On 1st September, bank takes section 34 possession. Is possession valid? The possession here will not be valid because the borrower yes. So the borrower here made representation within the period of 60 days and bank must consider it and give reasons before issuing notice under section 13(4). Bank is not obliged to accept the representation, but he has to consider. He has to consider the objection and he has to give reasons before issuing any section 13(4) repossession notice. Because section 13 subsection 3a says that if the borrower makes representation within 60 days, then bank shall consider and communicate reasons for non-acceptance. Failure to do so before taking any action under section 13(4) is invalid. Okay. Now, SURFACE versus IBC. So financial institution has recovery certificate from DRT against company A. Company A enters CIRP. Now financial institution applies to district magistrate under SURFACE Act section 14 for assistance in taking possession of the mortgage factory. Now what the DM should do? DM should reject this request because section 14 of IBC, दोनों में section है 14. Section 14 वहां पर भी है, सरफेसी में भी और आईबीसी में भी है. 14 सरफेसी का क्या बोलता है कि फॉर सीकिंग असिस्टेंस फ्रॉम डिस्ट्रिक्ट मजिस्ट्रेट और मेट्रोपॉलिटन मजिस्ट्रेट. So this request to DM should be rejected because section 14 of IBC, it stays any action to take possession of the CD assets. Non-registration consequence. So if a secured assets, so bank here creates mortgage on company B's factory on 1st January, but fails to register it with SURSAI within the prescribed time. So company B goes into liquidation in 2024 and bank claims the status of a secured creditor. Now what is the liquidator's position? So bank here is to be treated as unsecured creditor because it failed to register the security interest with SURSAI. Okay. So failure to register the security interest is unenforceable against the liquidator. So here the bank loan will be treated as unsecured loan and not as secured loan. So SURSAI registration is mandatory as per section 26C and section 26E says that unregistered security interest is void against the liquidator or IRP or receiver in insolvency. Okay. So post-liquidation registration cannot cure pre-liquidation defect. An IRP or liquidator must check the SURSAI database regarding this unregistered security. So unregistered security is unsecured creditor in CIRP or waterfall. Okay. Now MSMED Act, payment period and interest. Z Limited is a large company. It buys goods from P Limited, which is a micro enterprise. No credit period was agreed in writing. So Z pays 60 days after delivery and P claims this interest under MSMED Act. So Z argues because there was no agreement, so there was no obligation. So what is the correct position? So even if no credit period is agreed in writing, but P can claim interest for period beyond 45 days at 3 times the bank rate because it is a micro enterprises. So this facility is available to micro and small enterprises. Okay. So section 15 of MSMED Act says that if there is no agreement on payment period, buyer must pay within 45 days from date of acceptance. And statutory default overrides no agreement. And interest is payable at 3 times the RBI bank rate, compounded monthly from day 46. Okay. MSMED Act, Section 240, capital A of IBC. Mr. Gupta is promoter of Textiles Private Limited, which is a small enterprise. It goes into CIRP. Mr. Gupta gave a personal guarantee which was invoked and is party to Part 3 proceedings. So is Mr. Gupta eligible to submit a resolution plan? The answer will be yes, because Section 240 capital A, by virtue of this section, IBC exempts MSME promoters from Section 29A-C and 29A-H disqualifications. Okay. So these do not apply to resolution applicant in respect of MSME corporate debtors. Okay. Next is RERA regarding deposit of 70% in designated account. So project specific usage rule. So promoter X collects rupees 40 crores for project Alpha and he correctly deposits 28 crores, 70% in designated account. Then he withdraws rupees 12 crores from the designated account to acquire land for separate project Beta. So balance 16 crores is used for project Alpha construction. Is there a violation? Because cross usage is also prohibited. So if you have got money for a specific project, you have to utilize that money in that project only, right? So even a cross usage is considered violation. So withdrawal from designated account used for project Beta, although money was collected for project Alpha. So section 11 subsection 3 of RERA Act, it restricts usage to construction and land cost of that specific project only. Okay. RERA section 18, allottee remedies on delay. So developer D was to deliver flat to allottee A by 31st December 2023. But D, the developer fails. In March 2024, D was admitted into CIR. Now this A, who is the allottee, he wants a refund of 50 lakhs plus interest, or he wants to keep the flat plus compensation for delay. So these are the two options available. So what is his legal position? So he has got both options under section 18 of RERA. He can demand either refund of his money plus interest, or he can continue with the allotment plus interest. Exercise as financial creditor and CIR. If there is an agreement regarding interest, then that agreement will hold. Otherwise, 8% per annum interest. RERA section 3, registration threshold, disjunctive or logic. So builder B constructs 6 apartments in Gurgaon on a plot of 600 square meters. B argues because there are fewer than 8 apartments, so RERA registration is not required. But the correct position is RERA registration is required because plot area of 600 square meter, it exceeds 500 square meter regardless of apartment count. Okay. So section 3, dual threshold is disjunctive or. Okay. So registration is required if land area exceeds 500 square meter or apartments exceed 8. Either alone triggers registration. Mediation Act, MSA, challenge period. A and B execute a mediated settlement agreement on 1st of October 2024. A alleges B obtained mediated settlement agreement by fraud on 5th February 2025. A wants to challenge. What is the position? So there is a time limit. So A can challenge within 90 days of signing. So he should have challenged it by 30th December 2024. But challenge period has expired. So Section 28 of Mediation Act says that mediated settlement agreement may be challenged on grounds of fraud, corruption, impersonation, or non-mediatable subject within a period of 90 days from the date of mediated settlement agreement. So MSA was signed on 1st of October. So 90 days expired on 30th of December. Okay? So it is not challengeable because it is time bound. Commercial Courts Act plus Mediation Act plus pre-institution mediation. X Limited and Y Limited have a commercial dispute of 2 crores. X fears Y will immediately dissipate disputed goods and seek urgent injunction. So Y's lawyer says must first complete pre-institution mediation under Section 12A of Commercial Courts Act. So X's lawyer is correct because Section 12A says that mediation is mandatory, but there is an express exemption. But this Section 12A, it expressly exempts suits contemplating urgent interim relief and injunction to prevent dissipation qualifies. ठीक है, मान लो किसी के भागने का खतरा हो तो फिर ये एग्जम्पशन अप्लाई करेगी, फिर उसमें ये नहीं कि भैया आपको जरूर मीडिएशन में जाना है. DPDPA Act 2023. IRP X receives complete employee database of company Z. भाई एज IRP भी तो आपको डेटा मिलता है ना, तो 5000 एम्प्लॉइज का आपके पास आधार, बैंक अकाउंट, सैलरीज, सैलरी अकाउंट सब कुछ है आपके पास. X shares this with a potential resolution applicant for workforce assessment. ठीक है, so RA's consultant uses the data to poach employees. ठीक है, so under DPDPA Act, X may have violated IRP shall be considered to be violated DPDPA Act. ठीक है, sharing personal data beyond what CIRP strictly needs, so purpose limitation principle breached when RA used data for poaching. ठीक, because X जो IRP है, he is a data fiduciary. Employee यहाँ पर कौन है? Data principals. ठीक है, any individual whose data is processed is data principal. ठीक है, and no contract with IP is required. Statutory necessity क्या है? It is for legitimate basis only, but does not exempt from purpose limitation and data minimization. अब आपने क्या किया? आपने आधार, बैंक अकाउंट डिटेल्स आपने शेयर कर दिए which was beyond strict necessity and it was a potential violation. So X responsibility continues after sharing and it must include data protection clauses in resolution applicant NDA. वो जो नॉन डिस्क्लोजर एग्रीमेंट आप साइन करते हो ना रेजोल्यूशन एप्लीकेंट के साथ, उसमें ये भी आपको इंक्लूड करनी है डेटा प्रोटेक्शन क्लॉजेस. ठीक है, नाउ ईपीएफ प्लस आईबीसी एक्सक्लूजन फ्रॉम लिक्विडेशन स्टेट. कंपनी के इज इन लिक्विडेशन. एसेट्स हैं कैश 10 करोड़, फैक्ट्री 50 करोड़, ईपीएफ ट्रस्ट अकाउंट 3 करोड़, ग्रेचुटी फंड हेल्ड बाय एलआईसी 2 करोड़. सो लिक्विडेशन स्टेट अवेलेबल फॉर क्रेडिटर्स शैल बी कैश एंड फैक्ट्री. ठीक है, तो बोथ ईपीएफ जो आपका 3 करोड़ है और जो ग्रेचुटी है 2 करोड़ की, दैट इज एक्सक्लूडेड फ्रॉम द लिक्विडेशन एस्टेट. ठीक है, इस 36(4) में है. रिगार्डिंग ईपीएफ, RP is personally liable if you fail to pay the contribution. In a CIRP, RP fails to remit EPF contributions for the CIRP period. ठीक है, 6 months, 30 lakhs. A resolution plan was approved, but silent on CIRP period EPF dues. EPFO demands from RP personally. Correct position is RP is personally liable. So CIRP period EPF जो होगा ये CIRP कॉस्ट का पार्ट होगा, बट RP is failure to pay leads to personal liability. ये कर लिया हमने, दिस यू कैन सी ऑन योर ओन. ठीक है, तो ये थोड़ा सा हमने कवर कर लिया ब्रीफली जो हमारा so now let us cover briefly the SEBI laws. SEBI laws क्या होता है? I hope my screen is visible.
Yes, sir.
So SCRA एक्ट क्या कहता है? सिक्योरिटीज कॉन्ट्रैक्ट्स रेगुलेशन एक्ट. इसमें बेसिकली पूछेगा आपसे कुछ तो पेनल्टी के ऊपर पूछता है वो नॉर्मली, है ना. तो पेनल्टी वाला प्रोविजंस तो आपको याद रखने ही है इसके. The objective of SCRA Act is Securities Contracts Regulation Act is to prevent undesirable transactions in securities, to regulate the stock exchanges and to promote healthy market. It is applicable to whole of India and it has the power to recognize the stock exchanges. So central government delegated this power to SEBI. There are some key definitions also. जैसे स्पॉट डिलीवरी कॉन्ट्रैक्ट. स्पॉट डिलीवरी कॉन्ट्रैक्ट क्या है? सेम डे होगा या नेक्स्ट डे होगा. ठीक है, डिलीवरी एंड पेमेंट बोथ. रेडी डिलीवरी कॉन्ट्रैक्ट क्या है? विद इन 11 days. एंड ऑप्शंस इन सिक्योरिटीज है आपका तेजी, मंदी, पुट, कॉल एटसेट्रा. डेरिवेटिव कॉन्ट्रैक्ट्स क्या है? दे आर वैलिड ओनली इफ ट्रेडेड ऑन रिकॉग्नाइज्ड स्टॉक एक्सचेंजेस and settled by its clearing corporation. There are certain transactions which are prohibited. Section 13 talks of such transactions which are not routed through recognized stock exchange members. So these are considered to be illegal. The exception is if the transactions take place between two recognized stock exchange members. Contracts contravening recognized stock exchanges bylaw, section 14. So these are void except in case of स्पॉट डिलीवरी कॉन्ट्रैक्ट्स. दो ही चीजें याद रखनी है, कुछ डेफिनेशंस पूछ सकता है या फिर पेनल्टी प्रोविजंस नॉर्मली वो पूछता है. पेनल्टी प्रोविजंस क्या है? सेक्शन 23A, इफ यू फेल टू फर्निश एनी इंफॉर्मेशन और बुक्स. ठीक है, आपसे स्टॉक एक्सचेंजेस ने इंफॉर्मेशन मांगी एंड यू फेल टू प्रोवाइड दोज इंफॉर्मेशन. आपसे सेबी ने कुछ इंफॉर्मेशन मांगी स्टॉक एक्सचेंज से एंड you fail to furnish such information or books. तो क्या है? 1 लाख मिनिमम पेनल्टी है एंड अप टू 1 crore. ठीक है, 1 लाख टू 1 crore और इट कुड बी इवन 1 लाख पर डे. ठीक है. 23B है कि इफ यू एंटर इनटू कॉन्ट्रैक्ट्स व्हेन देयर इज नो क्लाइंट एग्रीमेंट, सो द पेनल्टी इज 1 लाख टू 1 crore. 23C talks of if you fail to redress the grievances of the investors without a genuine reason, then the penalty could be 1 lakh per day and it could go up to 1 crore. 23D is you have to keep the accounts of the client separate from your own accounts. So if there is a failure to segregate the funds of the client and you mix up the funds, your own funds with the client funds, then the penalty could range from 1 lakh to 1 crore. 23E talks of the non-compliances for listing or continuous listing. Because if you get your securities listed, then there are certain obligations which are cast upon you. And if you fail to fulfill those obligations, if you are found non-compliant, then the penalty could range from 5 lakh to 25 crore rupees. ठीक है। डीलिस्टिंग का अगर कोई नॉन कंप्लायंस है 5 लाख to 25 करोड़। फिर 23H क्या है, रेजिडुअल, जो पेनल्टी कहीं पर भी प्रेस्क्राइब नहीं है, तो फिर 1 लाख to 1 करोड़। सेक्शन 23 टॉक्स ऑफ क्रिमिनल प्रोसीडिंग, क्रिमिनल उसमें क्या होगा, इम्प्रिजनमेंट हो सकती है अप टू 10 years और फाइन अप टू 25 करोड़ और बोथ। ठीक है। और 23J में क्या है, इफ एओ कंसिडर्स गेन और लॉस टू इन्वेस्टर्स। ठीक है, कि भाई यू हैव डन सम गेन एट द लॉस ऑफ द इन्वेस्टर्स, और इफ इट इज ऑफ रेपिटेटिव नेचर, तो 23J में पेनल्टी। ये भी हो गया। लिस्टिंग ऑब्लिगेशंस एंड डिस्क्लोजर रिक्वायरमेंट्स। So if yours is a listed company, then there are certain obligations and disclosure requirements. वो क्या क्या है, कुछ requirements यहाँ पर हमने दे रखी हैं, जैसे board meetings. 4 board meetings shall take place in a financial year with a maximum time gap of 120 days between 2 meetings. Audit committee में, audit committee member shall be independent and at least 2/3 must be independent. An audit committee is to be chaired by a independent director. ये सारा आप देख लेंगे अपने हिसाब से, इसमें कोई दिक्कत नहीं है। जो टॉप 100 एंटिटीज है, उसकी एनुअल जनरल मीटिंग होनी है आपकी विद इन 5 months फ्रॉम द एंड ऑफ द फाइनेंशियल ईयर, बाय 31 अगस्त। नॉर्मली 6 months होता है, यहाँ पर 5 months किया। वेबसाइट कंटेंट में अगर कोई अपडेशन है, तो दैट यू हैव टू डू विद इन 2 working days एंड यू हैव टू मेंटेन ए वर्किंग वेबसाइट। इफ एनी फाइन और पेनल्टी इज लेविड अपॉन यू, फिर उसके लिए 24 आवर का डिस्क्लोजर रूल है। ठीक है। और अगर आप ये डिस्क्लोज नहीं करते, तो 1 लाख से या उससे ज्यादा की अगर आपको पेनल्टी लगी है कोई सेक्टरल नॉन कंप्लायंसेस के लिए, ठीक है, या 10 लाख से ज्यादा की पेनल्टी लगी है 10 लाख कोई अदर नॉन कंप्लायंसेस के लिए, तो यू हैव टू डिस्क्लोज इट विद इन 24 आवर्स। बोर्ड मीटिंग इंटीमेशन है विद इन 2 working days in advance. Annual report you have to dispatch to the shareholders not less than 21 days before the AGM. Dividend declaration before record date, 5 working days or more before the record date. ठीक। Substantial acquisition and substantial takeover, इसमें बेसिकली क्या है कि देयर इज ए टेक ओवर थ्रेशोल्ड, सब्सटेंशियल एक्विजिशन एंड टेक ओवर रेगुलेशंस। सो मैंडेटरी ओपन ऑफर ट्रिगर होगा। इसमें देखिए दो दो पार्टीज इन्वॉल्व है, एक तो है एक्वायरर और एक है पर्सन्स एक्टिंग इन कंसर्ट, मतलब विद ए कॉमन इंटेंशन। एक तो एक्वायरर हो गया, और दूसरा कौन है, जिस कंपनी को आप एक्वायर कर रहे हो। ठीक है। So there is a mandatory open offer trigger when the acquirer or persons acting in concert want to acquire 25% or more of voting rights. ठीक। There is a concept of creeping acquisition also. इसमें क्या है कि if you are already holding between 25% to 75% and you want to acquire up to 5% additional in financial year, so then also it is considered a creeping acquisition. So any acquisition or of control triggers mandatory open offer. ठीक है। एक तो हो गया आपका एक्वायरर और दूसरा हो गया टारगेट कंपनी। जो एक्वायरर है, इट कुड बी नेचुरल पर्सन ऑल्सो, कोई भी हो सकता है। ठीक है। तो एनी एक्विजिशन ऑफ कंट्रोल ट्रिगर्स मैंडेटरी ओपन ऑफर। तो मैंडेटरी ओपन ऑफर कितना साइज होगा? मिनिमम 26% ऑफ टोटल शेयर्स। इसके पीछे बेसिक लॉजिक क्या है? बेसिक लॉजिक ये है कि इफ यू आर ऑलरेडी होल्डिंग 25%, ठीक है, तो 25% में इसका मतलब स्पेशल रेजोल्यूशन में तो आप पंगा डाल ही सकते हो, है ना? कई जगह मोर देन 75% रिक्वायरमेंट है। तो वो ये कहता है कि भैया आप 26% और एक्वायर कर लो, ठीक है, ताकि रेजोल्यूशन, ऑर्डिनरी रेजोल्यूशन भी तुम्हारे बिना ना पास हो सके। ठीक है। तो मैंडेटरी ओपन ऑफर दे दो आप, बिकॉज इट इज कंसिडर्ड टू बी ए सब्सटैंशियल एक्विजिशन। इट इज डीम्ड कि भाई आपने सब्सटैंशियल एक्विजिशन या सब्सटैंशियल टेक ओवर कर लिया उस कंपनी का। ठीक है। तो 25% आपके पास है, 26% और ले लो फिर आप, ये कहना चाह रहा हूं। उससे क्या होगा? मैनेजमेंट चेंज हो जाएगा, कोई ऑर्डिनरी रेजोल्यूशन भी पास नहीं हो पाएगा। ठीक है। डिस्क्लोजर ऑन क्रॉसिंग थ्रेशोल्ड विद इन 2 वर्किंग डेज। एनुअल डिस्क्लोजर ये है कि if you are holding more than 25%, then you have to disclose this within 7 working days of the financial year end. ठीक है। प्रोमोटर का क्वार्टरली डिस्क्लोजर है विद इन 7 वर्किंग डेज ऑफ द एंड ऑफ द क्वार्टर। और पोस्ट ऑफर रिस्ट्रिक्शन है 6 months फ्रॉम द डेट ऑफ कंप्लीशन ऑफ द ऑफर। आईसीडीआर रेगुलेशंस है कुछ, इश्यू ऑफ कैपिटल एंड डिस्क्लोजर रिक्वायरमेंट्स। इसमें क्या है कि कुछ कैपिटल इश्यूज के लिए थ्रेशोल्ड्स है। आज बेसिक बेसिक बातें डिस्कस कर रहे हैं ताकि जब आप पढ़ोगे तो आपको समझ में आ जाएगा। ठीक है। एक तो है इसमें प्रॉफिटेबिलिटी रूट। प्रॉफिटेबिलिटी रूट क्या कहता है कि आपके जो नेट टेंजिबल एसेट्स हैं दे शुड एक्सीड 3 करोड़, एवरेज ऑपरेटिंग प्रॉफिट शुड एक्सीड 15 करोड़, और नेटवर्थ शुड बी 1 करोड़ और मोर इन ईच ऑफ द 3 प्रीसीडिंग फुल ईयर्स। ठीक है। और ऑपरेटिंग प्रॉफिट में ये है कि किसी भी साल में लॉस नहीं होना चाहिए। एक तो ये वाला प्रॉफिटेबिलिटी रूट है। ठीक है। अगर आपको इश्यू ऑफ कैपिटल करना है तो। ठीक है। दूसरा क्या है कि मान लो आप ये कर ही नहीं सकते क्योंकि आपकी लॉस मेकिंग कंपनी है, तो फिर उस केस में बुक बिल्डिंग रूट है। बुक बिल्डिंग रूट में क्या है कि लॉस मेकिंग इश्यूअर्स दे आर एलिजिबल इफ you are able to sell 75% of the 75% or more of the net offer to qualified institutional buyers। qualified institutional buyers क्या है? बेसिकली जो म्यूचुअल फंड्स हैं, एसेट मैनेजमेंट कंपनीज हैं, एसेट रिकंस्ट्रक्शन कंपनीज हैं, बेसिकली वो। ठीक है। दोज हु हैव द नॉलेज अबाउट द कंपनीज, अबाउट इन्वेस्टमेंट। ठीक है। तो सेबी भी ये समझ रही है कि भाई अगर वो लोग 75% खरीद रहे हैं तो फिर कोई दिक्कत नहीं। ठीक है। मिनिमम प्रमोटर कंट्रीब्यूशन कितना है? ये आपका है 20% और मोर ऑफ पोस्ट इश्यू कैपिटल। प्रोमोटर लॉक इन मिनिमम 20% है। इट इज 3 years फ्रॉम द अलॉटमेंट ऑफ कमर्शियल प्रोडक्शन। ठीक है। और अगर आपका कोई एक्सेस कंट्रीब्यूशन है, ठीक है, मोर देन 20%, तो उसके लिए इट इज 1 year फ्रॉम द अलॉटमेंट लॉक इन पीरियड। ठीक है। जो नॉन प्रोमोटर प्री इश्यू लॉक इन है वो 6 months रिक्वायरमेंट है। बुक बिल्डिंग एलोकेशन में क्या है कि क्वालिफाइड इंस्टीट्यूशनल बायर्स 50%। ठीक है। ये एनआईआई 15% है आपके, और आरआईआई है 35%। मिनिमम सब्सक्रिप्शन 90% ऑफ इशू। इफ यू डू नॉट गेट देन यू हैव टू रिफंड विद इन 15 days। ठीक है। और एमएस ई प्लेटफॉर्म का भी है इसमें कि इन दिस केस द इशू साइज इज 10 करोड़ to 25 करोड़। डी लिस्टिंग में क्या है? डी लिस्टिंग के केस में सेबी डी लिस्टिंग रेगुलेशंस है। इसमें दो तरह की डी लिस्टिंग है, एक तो है वॉलंटरी डी लिस्टिंग और एक है कंपल्सरी डी लिस्टिंग। वॉलंटरी डी लिस्टिंग में भी दो रूट्स हैं। क्या? पहला रूट, if you want to delist from one or more stock exchanges, but if you continue to be listed on one or more stock exchanges which are having nationwide trading terminals। ठीक है। उसमें सिंपल प्रोसीजर है कि आपको सिर्फ जो है बोर्ड का रेजोल्यूशन चाहिए और उसमें शेयर होल्डर्स का रेजोल्यूशन नहीं चाहिए। ठीक है। लेकिन इफ यू वांट टू डिलिस्ट फ्रॉम ऑल, तो आपको बोर्ड का रेजोल्यूशन भी चाहिए और फिर शेयर होल्डर्स का रेजोल्यूशन भी चाहिए। ठीक। और अगर वॉलंटरी डीलिस्टिंग करनी है आपको, तो उस केस में क्या है कि 2/3 ऑफ पब्लिक शेयर होल्डर्स मस्ट अप्रूव दिस रेजोल्यूशन। देर आर सर्टन डिस्क्वालिफिकेशन ऑल्सो व्हेन यू कैनॉट डीलिस्ट। अगर 3 साल से कम हुए आपको लिस्ट हुए हुए, देन यू कैनॉट डीलिस्ट। ठीक है। Or if it is less than 6 months since the last buyback or preferential allotment, or if the acquirer has sold his shares within 6 months of the IPA, then you cannot apply for delisting. ठीक है। यूज ऑफ कंपनीज ओन फंड्स बाय एक्वायरर आर प्रोहिबिटेड। ये आपका है एलओडीआर। एलओडीआर में क्या हुआ, कुछ अमेंडमेंट्स हुए आपके 24 में, तो उसमें कुछ की चेंजेस है। क्या क्या चेंजेस है उसको देख लेते हैं। एक तो है डेफिनेशन ऑफ मटेरियल सब्सिडरी। तो इसमें इनकम वाज रिप्लेस्ड बाय टर्नओवर। कंप्लायंस ऑफिसर, इट मस्ट बी होल टाइम केएमपी, 1 level below the board, not just qualified CS. हाफ ईयरली कंप्लायंस सर्टिफिकेट टू एक्सचेंज, इट वाज रिमूव्ड। ठीक है। इन्वेस्टर ग्रीवांस, इट वाज इंटीग्रेटेड क्वार्टरली फाइलिंग विद इन 30 days, रिप्लेसिंग ओल्ड 21 days सेपरेट स्टेटमेंट। सीनियर मैनेजमेंट में CS एंड CFO was replaced by persons identified as KMP other than board। ठीक है। जो नॉन एग्जीक्यूटिव डायरेक्टर है, इफ इज टर्निंग 75%, देन स्पेशल रेजोल्यूशन मस्ट बी obtained बिफोर अटेनिंग द एज ऑफ 75 years। ठीक है। कुछ स्पेशल राइट्स इक्विटी शेयर्स हैं। सो न्यू डेफिनेशन इज इंसर्टेड फॉर टेक फाउंडर्स विद डिफरेंशियल वोटिंग राइट्स। ठीक है। एंड एंटिटीज विच आर रैंक्ड फ्रॉम 1000 to 2000, एटलीस्ट वन वुमेन इंडिपेंडेंट डायरेक्टर इज नाउ मैंडेटरी। ठीक है। एक्विजिशन डिस्क्लोजर थ्रेशोल्ड इज रेज्ड फ्रॉम 5% to 20%। ठीक है। इन केस ऑफ इट इज मटेरियल इवेंट, एंड फ्रॉम 2% to 5% रिपोर्टिंग इवेंट। तो आज इतना ही करते हैं। मैं आपको ये दोनों जो पीपीटी से शेयर कर दूंगा, यू कैन गो थ्रू, और फिर नेक्स्ट स्लाइड, नेक्स्ट क्लास में हम लोग इसको कंटिन्यू करेंगे। नेक्स्ट क्लास में हम लोग करेंगे कंपनीज एक्ट और पार्टनरशिप एक्ट LLP। ओके जी, गुड नाइट।
थैंक यू सर।
थैंक यू।